afternoon, ladies and gentlemen. I'd like to welcome you all to this 2868th meeting of the Human Rights Committee, where we are examining the 5th report of Yemen. But first, let me warmly welcome Her Excellency Hooriya Ahmed, the leader of the delegation and also the Minister of Human Rights in Yemen. She's accompanied by the Ambassador, His Excellency Gerald L, as well as the Director General of the Ministry of Human Rights, Mr. Manaf Al-Salahi. You're most welcome. We're really grateful that you were able to come despite all the difficulties you face at the present moment in your country. Your Excellency, I understand that you have retracted the replies to the list of issues, but nonetheless, we will expect to get some oral replies. And let me explain how we shall proceed this afternoon. Yes. We have a long list of issues that we had wanted you to pay attention to, but we will be happy if you provide us with oral replies to issues 1 to 18 after you've made your opening statement. But we think that the rest of the issues can be addressed tomorrow. So for today, we'll just consider issues 1 to 18 and expect oral replies from you. Without much ado, I give you the floor, Your Excellency.
In the name of God, most gracious, most merciful, Madam Chair, ladies and gentlemen, members of the committee. At the outset, I would like to present to you the members, the Ambassador of Yemen to the United Nations in New York, Mr. Manaf Al-Salahi, Director General of the Organizations and International Reports, Mr. Taha Al-Awadi, responsible for the humanitarian affairs. I would like also to draw your attention to the fact that the report that you received is not the last report, the most recent report. There are some inaccuracies in the report that you have received. Therefore, I would like your indulgence so that we can send you the final version of the report. But in general, I would say that the report that you have received was indeed the general report. However, as I said, there were some mistakes. Therefore, this is not the final report. Ladies and gentlemen, on behalf of the delegation of the Yemeni Republic, I am very happy to participate in this 104th meeting of the Human Rights Committee, during which we exchange the experience and the information about the human rights endeavors in our respective countries, and during which we are going to evaluate to what extent we are committed to enforce the Covenant on Civil and Political Rights. In 2009, we have presented to you the 4th country report, and today we are presenting to you our 5th country report, in which we have mentioned the difficulties and the obstacles that have faced us in the full implementation and enforcement of this covenant. We are going to give you our vision as to the protection of civil and political rights, and we have the hope that we can indeed overcome the difficulties that we have, both through our own own efforts and with the support of the stakeholders. And here I would refer to the sponsors of the political settlement proposed by the GCC countries and its executive mechanism and the Security Council Resolution 2014. The delegation of my country will be happy to give you a concise explanation of the legislative, judicial, administrative measures that have been taken by the Yemeni government in implementing the Covenant on Civil and Political Rights, taking into consideration the recent developments in our country. And we are going, of course, to answer the questions of the committee. The situation in Yemen during the year 2011 were linked, of course, to the Arab Spring events. And during that year, there were peaceful demonstrations during which the young people of Yemen had the demands for change, for a civil state that would preserve their dignity, their freedom, their justice, and citizenship rights based on equality and the protection of public rights and freedoms. And although in the beginning the revolution was a peaceful one, there were acts of violence and armed confrontations, and there were serious infringement of the human rights. And indeed, there were a lot of victims. And according to the preliminary reports, there were 2,000 martyrs, among whom were 143 children, 20 women, and 22,000 injured with temporary and permanent handicaps. And this in addition to the destruction of the infrastructure and the deterioration of the basic services and the shortage of electricity, pure and fresh water, oil byproducts, gasoline for household, and the economic deterioration in general. And the result was the closing of more than 800 economic establishments, with 1 million of workers having lost their jobs. And in the fear of the destruction and the chaos as a result of a looming civil war, the Gulf GCC countries have proposed their initiative for a peaceful transition that avoids the violence, and this was within the agreement or the consensus on the international scale. And in July of last year, the High Commission had a mission that was sent to Yemen, and the Human Rights Council has issued a report that, and also in addition to the Security Council report 2014 against the violence used against the peaceful demonstrators in Yemen, and the serious absence of security in Yemen, as well as the deterioration of the economic and the humanitarian situation. And such efforts and international decisions had a positive impact that led to the political settlement with the signature by the ruling party and its alliances and the partners in the GCC countries, and the signing of the executive mechanism on the 23rd of November 2011. The following were the matters that were agreed upon. First of all, the establishment of a government based on the national consensus and based also on the executive mechanism within the time framework within the GCC initiative, and with the following with the following goals to be fulfilled. First of all, the security and stability and the recomposition of the army, the holding of a national dialogue conference, the reinstating of a new constitution, and the reform of the political situation and system, also the reform of the election system, as well as the election in the House of Representatives and the Parliament in accordance with the new constitution, and exerting efforts to improve the economic and social situation and development. Also, among the goals, the establishment of a committee on the military issues and the security and stability against the violence. And also, in response to your questions, ladies and gentlemen, the Yemeni government has also received a number of lists, the list of questions during the preparation of the fifth country report. And also we have gone through all the issues that were included in the report and the efforts exerted by Yemen in this regard. And we, of course, have the pleasure to give you the clarifications and the answers to the questions, and, of course, with due professionalism in tackling such issues. And, of course, we are going to give you the information about the recent developments in Yemen regarding human rights. The list of clarifications and questions asked for a number of answers on the legislative and judicial as well as administrative measures that were taken in terms of a number of issues, such as the issue of southern Yemen, also the establishment of human rights-related independent organizations, infringements of the human rights, including the killings, as well as the imprisonment and arrests and arbitrary arrest and torture, as well as the oppression against the demonstrators and journalists, as well as the inspection and the also all kinds of arrangements against the human rights. And of course, there are a number of obstacles that hinder the implementation of the covenant in reality. And we have also indicated that such issues are related to the political and economical issues, as well as things related to stability and security. And we indeed had to look for the political as well as economic and social solutions. And the participation of young men and women in the demonstrations was a result of such difficulties that we had in Yemen in terms of the implementation of human rights. Those young people are looking forward to have a civil state that respected the freedom, equality, and the dignity in such a democratic environment where there will be the rule of the law and the full respect of human rights. Our answers regarding the issue of the South. With reference to the paragraph 21 of the mechanism that reads as follows, that the dialogue regarding the South is based on an equitable national solution that would preserve the unity and the integrity of the Yemeni territories, as well as the stability and security of Yemen. And in terms of the stoppage of the infringements of human rights, the new government of national consensus in its program that included a number of goals in terms of the public policy, and that this program was also endorsed by the Ministry of Human Rights. this program endeavors to activate and implement the rule of the law. And as you know, there was a political settlement that gave the previous president of Yemen the immunity from accountability. And the law may indeed give more possibilities to a kind of justice in this transitional period, in such a way that there would be investigation in all forms of infringements of the human rights, whereby there will be remedies given to the victims, and also there will be measures that would guarantee that such infringements would not be repeated in the future.
The draft law also included measures that called for comprehensive institutional reform of the agencies that participated and or were involved in human rights violations. There's the discussion of the draft law continues with the various national, political, legal, social components and the victims of the violations in order to enrich this discussion concerning legislative and institutional reforms. The planned constitutional reforms, according to the mechanism of implementation, aim primarily to the reform of the political system and promoting and protecting the civil and political rights of the citizens in order to guarantee their freedoms and rights by enacting and reforming the relative legislation in accordance with the relevant international covenants. The mechanism of implementation has included the statement that, quote, the National Dialogue Conference must consider the drafting of the Constitution, including creating a drafting commission and deciding its members. It will also discuss constitutional reform and the reform of the state's structure, the political system, and suggesting constitutional reforms in order to submit them to a referendum by the people of Yemen, as well as adopting legal steps and other steps to strengthen vulnerable groups, including children and women. Concerning the democratic system, the National Dialogue Conference must take steps to move forward in building a comprehensive democratic system, including civil service reform, justice reform, reform of the local administration, and guaranteeing the neutrality and independence of the media. Ladies and gentlemen, these are the ideas for the future. As for the actual measures and steps taken at present or recently, concerning criminal justice, the second national conference for dialogue concerning criminal justice in the Yemeni law was held in the capital Sana'a on the 27th and 28th of June 2010. It was organized by the Ministry of Human Rights in cooperation with the Danish Institute for Human Rights and with wide participation from the various government and non-government agencies, including members of the judicial authority, lawyers, representatives of local authority, parliamentarians, academics, security agency members, and representatives of the civil society and journalists. The conference went on for 2 days, during which the participants discussed 5 main pillars for the reform of criminal justice, including the requirements of legal reform, creating and developing a code of conduct for law enforcement personnel, discussing the needs for developing the institutional functioning of prisons, the alignment of criminal legislation and criminal justice laws with the relevant international covenants, and raising awareness concerning these laws among various members of the society and members of the executive agencies, as well as promoting the culture of human rights and the rule of law. This second dialogue conference submitted a program for reform in the form of a discussion paper to be discussed with the various lawmakers and the main stakeholders, including donor entities, in order to enable us to begin implementing an effective reform program. And this conference will submit recommendations to be discussed by the participants in order to take into consideration the inputs and recommendations that will take shape in the form of the final program for the reform of the criminal justice system. This will be followed by the third conference of donors concerning criminal justice, and the plan for reform will be submitted to that conference, as well as a number of projects which will be discussed with various international organizations and donor countries in order to finance them. Concerning the creation of an independent national commission for human rights, this is a main task that is part of the plan of the Ministry of Human Rights for the near future. There's a number of steps and preparatory stages to carry this out in coordination with civil society organizations as well as international entities, including the High Commission for Human Rights. In this context, the Council of Ministers has made a decision to open an office in Yemen for the High Commission for Human Rights to strengthen cooperation in human rights between our country and the Commission, with a view to building capacities and providing necessary financial and consultative assistance for the creation of this National Commission for Human Rights in Yemen. In February, we received a delegation from the High Commission for Human Rights in order to begin the steps for carrying forward for implementing the resolution of the Human Rights Commission concerning Human Rights Council concerning Yemen, which was issued on September 29, 2011. We are looking forward to having all United Nations agencies and donor countries support Yemen and assist it to overcome its crisis and revive its economy, which will undoubtedly improve the living standards of the people and promote their basic human rights. Concerning arrests, the Council of Ministers issued resolution number 12 for the year 2012 concerning the release of those who were held illegally and closing down all improvised and illegal detention centers. The Military Affairs Committee has ordered all military and security units and other relevant entities in Sana'a and the rest of the provinces to release those who were arrested during the recent events and emphasize that it will continue following up on these instructions and will hold accountable any entity that violates these instructions. Concerning carrying out independent and transparent investigations concerning the grave violations of human rights, the Council of Ministers issued Order number 4 for the year 2012 to form a ministerial committee to study the creation of an independent investigation committee and to provide a plan for its functions and its tasks in line with international standards in order to investigate the claims concerning violations of human rights. Concerning the compensation for families and for victims, the Council of Ministers resolution number 4 concerning the reconstruction of buildings and public buildings that were damaged by the crisis also included the creation of a committee to put together plans and budgets for the reconstruction of government buildings that were affected by the crisis and to prepare an inventory of the other buildings in order to be included in these programs. There will be a mechanism for compensation as soon as these investigations are finished, and there will be new laws for as soon as new laws for national conciliation and transitional justice have been made, and when the economic circumstances have improved. Concerning women, the National Commission for Women has prepared a national strategy for the development of women for the period 2006 to 2015 with focus on 6 strategic goals that include the promotion of women's education, health, as well as economically and politically, and policies for combating violence against women and preventing discrimination against them, in implementation of CEDAW, and in implementation of the and this strategy is being implemented in national plans. The Yemeni women have stunned the world with their wide participation in the Yemeni Spring, where they demanded their rights and the rights of the entire society. It was not by chance that a Yemeni citizen, Tawakkul Kerman, received the Nobel Peace Prize for 2010, together with the two Liberian women, Eileen Johnson and Lima Jabwi. This was a recognition by the world of the role of the Yemeni woman in a society that had witnessed great violence and armed conflicts. The recent years, and by virtue of the struggle of Yemeni women, have witnessed the amendment and the issuance of new laws to guarantee women's public and private rights. However, there are other laws that have resisted amendments or implementation, and they are still being subject to efforts to carry them out. The transfer of power mechanism has included in various parts of it the need to involve women in all measures, and the government will also work through the new constitution to promote the rights of women and remove any gender-based discrimination. Madam Chair, ladies and gentlemen, we believe that these reforms will undoubtedly lead to a positive and qualitative change in the field of promoting human rights. However, we have many and grave challenges, and I will here mention some of the most important challenges that face my country and prevent the implementation of the international covenant. Number one, the spread of poverty, especially in rural areas and among women. Poverty is one of the most serious dangers surrounding human rights and human freedoms. Poverty is also a structural complication that prevent innovations in the field of human rights, because our efforts so far are focused on providing the minimum of rights and livelihood at a time when there are increasing demands for a qualitative jump in rights and in private and public rights. Number two, in addition to the areas in which to the imbalance that Yemen suffers in terms of the population distribution, which also creates difficulties in providing basic services to all the population areas, including providing justice and courts and general prosecution services. C, inadequate training programs at present for raising awareness about human rights in international covenants among judicial officers and the employees of correctional facilities. D, the inavailability of sufficient financial resources to cover the needs of prisons, including construction and repairs, and providing all the rights that must be presented to the employees to the prisoners because of the lack of resources. E, the lack of an effective system which combines all statistical information among all government agencies, including information about their activities and the legal references and legal and projects that are being carried out so that a joint national planning can take place. F, the lack and the weakness of national mechanism for the protection of human rights, and the weakness of regulatory and supervisory entities that oversee security and military establishments. Next, there is the lack of the capacities of the institutions and the official and unofficial entities concerned with human rights. There is the lack of social awareness of rights and duties among a great number of society. There is the spread of weapons and the weakness of the state's authority and the absence of the concept of the rule of law. There is the lack of trust in the judicial system and the security forces and the spread of corruption. There are the security troubles and the increased threats by Al-Qaeda organization. on this occasion, we call upon the Human Rights Commission and other commissions established by virtue of international covenants, as well as all civil society organizations, to create a true partnership with the government in order to promote human rights in developing countries, on the basis of a commitment to promote these rights. In conclusion, the government of the Republic of Yemen expresses its deep gratitude and appreciation for the members of this commission for their continued efforts to promote human rights in various states, in the various countries in the world, and we express our readiness to start a transparent and a positive dialogue with the committee and respond to its inquiries, and we thank you for your attention. Thank you.
I thank you, Your Excellency, for your informative opening statement. It certainly gives us some insight into what is happening in Yemen at the present time. I will I'll open the floor to members of the committee to start the dialogue with your delegation. And the first person I'll call upon is Mr. Bouzid. You have the floor, sir.
شكرا سيدة الرئيسة.
Thank you, Madam Chair. At the outset, I welcome very warmly the delegation of Yemen, and I thank Her Excellency the Minister for this introductory statement, which introduced the responses to the list of questions. At the outset, also, I would like to mention that 80% of the report is accurate and 20% must be amended according to what you said. Do you mean the 5th periodic report, or do you mean the list of questions and your responses to those questions? You said report. Did you mean the periodic report submitted in 2009, or were you talking about the list of replies submitted to the committee? My second point, I would like to note with approval the commitment of the National Accord Committee, their commitment to uphold human rights and removing the causes that led to human rights violation and making that one of their priorities. And they have won the vote of confidence based on that plan. I believe that these commitments and promises are a result of the Yemeni uprising in 2011, which embodied democracy, transparency, the elimination of political and social corruption, and the respect of the rights of the Yemenis men and women. I will focus my questions on 4 points. The first point concerning the first item of the covenant. The government was asked to explain the political and legal measures concerning the right for self-determination in relation to the separatist movement in the south. There were 2 replies presented in the 5th periodic report. There was a lengthy explanation in response to this inquiry about the law of local administration. There were approximately 31 paragraphs and 8 entire pages to explain the local administration law. And I understood from this that the intent of the government was to discuss local administration, meaning administrative decentralization. In other words, it is not political decentralization, and there is no space for talking about that. But the answer that you gave us now in the reply of the National Accord government, you said that according to the mechanism of implementation of the GCC initiative, the question of the South will be subject to discussion in the National Reconciliation Conference, and you said that that would be in order to achieve a just national solution that would preserve the unity and stability of Yemen. What do we understand from that? That administrative decentralization as a solution for the South is now a bygone matter, and that we are now thinking of the South as a political matter which can be resolved in a federated or confederated format? Or do we understand that there is now a total dismissal of the idea of separation? You have said that the solution will be formulated in the Constitution. So we want that to be elaborated. Also, a lot of the information submitted to us and submitted by non-government organizations stated that the troubles and in the South since 2007, which continue to this day, are a result of the economic inequality and the oppression by the central government. This is what the reports say, and that these activities and demonstrations are met with great cruelty by security forces, and that in these demonstrations, large numbers of the demonstrators get arrested, though most of them would later be released, but many of them are detained for lengthy periods and are, according to these reports, are subjected to torture and inhumane treatment. Among these, the reports mention well-known names of Southern leading figures which remain to this day in prisons and detention centers. We want clarifications from you. How true is this? This includes Qasim Askar Jubran, Fadi Bahoum, and others. What are your comments on these reports? We also have reports that indicate that despite the issuance of a presidential decree in 2008 concerning the reintegration of more than 15,000 military personnel who were retired as a result of the 1997 events, the troubles with the South, the actual implementation only affected 66% only of this number. We want clarification. Does the National Accord government want to implement this decree and reintegrate these members in the armed forces in order to mend fences and bridge the gap with the various parts of the country? Concerning the second question, which deals with the extent of the use of the international covenant by the Yemeni courts. According to Article 6 of the current constitution in Yemen, Yemen is bound to implement the International Covenant for Human Rights and the International Law and the UN Charter and the Arab Covenant for Civil and Political Rights. But the Constitution does not create actual mechanisms for implementing that. So what are the measures that the National Accord government wants to adopt in order to implement international agreements, including the Covenant, and making them one of the sources used by the courts in reaching judgments and making decisions? Will the new constitution be an opportunity to solve this dilemma finally? And will this be an official implementation by Yemen of these obligations? Also, and because of all the events in Yemen, including a fight against terrorism, against Al-Qaeda, against the Houthis, the various complications, the struggle among the tribes. We want to know, can the government shed some light on the existing security situation? Can the government guarantee the implementation of the covenant throughout the entire country, including in these exceptional circumstances in Yemen? Concerning the third question about the creation of an independent entity for human rights according to the Paris Principles. In the fourth report in the summer of 2005, the Yemeni government made a commitment to create that independent entity, and our committee appreciated that promise, but so far this has not been implemented. And today in your statement you said that the government intends to implement this priority and will take the necessary measures and steps to create an independent entity for human rights according to the Paris Principles. My question is, what are these measures which the government will carry out in the near future? And will these measures take place before the National Comprehensive Conference, or will the natural place to deal with this the National Conference? My fourth and last question is, everybody knows that Yemen faces grave security challenges, from terrorism to the Houthis, to the tribal conflicts, to the problems in the south. And Yemen, of course, has all the right to maintain its security and stability, but this task must be carried out by security forces with total respect and firm respect for human rights, including the right to life, the prevention of torture, and inhumane treatment, and fair and just trials. The reports we have, which were submitted by NGOs, provide a lot of living examples of the lack of respect by Yemeni forces of the rights which should be respected in all circumstances. There are names of people who were victims of extrajudicial killings, who were treated with extreme cruelty and torture, who were imprisoned for lengthy periods. There are cases of forced disappearances. The question is there a tendency to carry out a comprehensive reform of security entities, especially those responsible for the excessive use of force? Another question: what is the fate, or what will be the fate, of the recommendations of the Parliamentary Investigative Committee in the events of Lahj and Abyeh, where it was acknowledged that there were grave violations of human rights, and the recommendation to submit those responsible to justice and to investigate the complaints of the victims and punish those responsible? Does the National Accord government intend to carry out the recommendations of that committee? Finally, you have just mentioned that the Council of Ministers issued a number of resolutions and decrees, resolution number 4 and resolution number 12, especially the one dealing with the release of the detainees, of the illegally held detainees, and closing down the illegal detention centers. Of course, we appreciate that, but my question is is the government in a position of total control of the security forces, given the division that is now in existence in the armed forces? This is what we heard from NGOs, and we want you to confirm or deny that. We heard that even the decrees of the President of the Republic and of the government are not being carried out in the field, because this division in the army has made some leaderships unwilling to acknowledge and implement these resolutions. We want some clarifications in this respect. Thank you.
Thank you, Mr. Bouzid. I now give the floor to Mr. IWASAWA.
Thank you very much, Madam Chair. I join my colleagues in extending a very warm welcome to Excellency and other members of the distinguished delegation of Yemen. I will ask questions on issues number 5, 6, 7, 8, and 17 and 18. First of all, issue number 5, on discrimination in all fields. The report of Yemen gives no new information on Article 26. Does that mean that no progress has been made with regard to protection against discrimination? The report describes various processes to bring Yemen's domestic laws into line with the international human rights treaties. Have any of these processes resulted in measures addressing discrimination? In the new constitution, is any progress envisaged for protection against discrimination? And if there are any court decisions relating to protection against discrimination in all fields, could the distinguished delegation give us examples? I would like now to move to issue number 6, social status of women. Excellency, the head of the delegation stated in your opening statement that the new constitution will enhance rights of women. I'm very interested in this statement, and I would like to more details on this point. Could the distinguished delegation explain how the new constitution will enhance rights of women? And in the report the government submitted, we take note that the government of Yemen recognizes that women's participation in public life is important. And I welcome this recognition. And we welcome the reforms that the government of Yemen is trying to implement in its legislation with regard to the social status of women. The first issue I'd like to take up on the social status of women is the low political representation of women. The report of Yemen mentions a draft amendment to the Elections Act establishing a system of temporary positive discrimination in favor of women. Could the distinguished delegation explain the current status of this amendment? The next issue is voting rate of women. Have there been an increase in the percentage of women voting? I would appreciate it if the distinguished delegation would explain voting rate of women in the presidential election, which took place in February this year. The next issue is the low representation of women among prosecutors and in the judiciary. What measures are taken to recruit and train women prosecutors and judges? The next issue is women in the police force. We take note of the added article to the Police Act granting Yemeni women the right to serve in the police force. Since these provisions came into force, what percentage of police officers are women? Have there been measures to ensure the presence of women officers during arrest and interrogation of women? The next issue I'd like to ask is women's education. Has there been progress toward reducing tuition fees for girls and eliminating them altogether for girls from poor families? Next issue, issue number 6 is detention of women. I'd like to know currently how many women are unwillingly remaining in prison after having served their sentences. How many women are unwillingly remaining in prison after having served their sentences? Has there been further progress in this regard since the last report? Now, I'd like to now move to issue number 7 on descent-based discrimination. Could the distinguished delegation provide information on how many marginalized communities exist in women other than the Al-Qahadam community? Now, with regard to the Al-Qahadam community, the human rights situation of these people has been raised consistently by a number of UN treaty bodies, but it seems that little progress has been made. What are the most significant obstacles in dealing with this issue? Have the root causes of the problem been identified? Please indicate how the government intends to tackle the problem. In the context of the ongoing unrest, it is reported that the Al-Qahadam are largely considered to be supportive of former President Saleh and therefore have suffered from acts of aggression and intimidation by former opposition supporters. Could the distinguished delegation comment on the contention? Now, I'd like to move on to issue number 8, legal status of women. And I will address first issues relating to the personal status law. And under this personal status law, the first issue I'd like to take up is polygamy, which is provided for by Article 12. The report of Yemen explains measures adding conditions for polygamy, But the real problem is polygamy itself. Has there been a decrease in the number of cases of polygamy? We lost a member of the committee, Mr. Amo, in January this year. He passed away, sadly, in January this year. He was a Muslim, and he was critical of the system of polygamy. If he were alive today, he would ask the same questions, but in a much more eloquent and forceful way. I'd like to now turn to Article 40 of the Personal Status Law. Article 40 provides that the wife must obey her husband and cannot leave the house without his permission. And it also condones marital rape. This article greatly constrains rights of women. Could the distinguished delegation explain why this article must be maintained? The next issue is consent to marriage. According to the information before us, women and girls are often forced into marriage. Article 23 of the Personal Status Law provides that while a previously married woman, that is, a non-virgin, must consent to marriage, a virgin's silence signifies her consent. Article 14 of the Personal Status Law provides that the marriage should be registered by the groom or male family member, which makes it impossible for authorities to confirm a woman's will to marry. Could the distinguished delegation explain how women's consent can be respected under those provisions? The next issue I'd like to take up under issue number 8 is divorce. Article 59 of the Personal Status Law provides that a man may divorce his wife at will, while women must petition a court. A woman can receive compensation only under limited situations and may not be able to acquire custody of children. These provisions appear discriminatory to women. We were told of a story of an 11-year-old girl who was forced to marry a 40-year-old man and was abused. She was granted a divorce, but only on the condition that the dower is paid back. And since her family was unable to pay back the dower, she suffered from more abuses. Can the law be changed so that a young girl in such a situation can obtain a divorce without paying back the dower? The next issue I'd like to take up is inheritance. Under the family law of Yemen, daughters are entitled to only half of what the sons inherit. And in practice, men often receive all of the inheritance. Could the distinguished delegation provide us with statistical data indicating in practice what percentage women inherit in comparison to men, and explain how the situation can be justified under the covenant? Now, I'd like to turn to the criminal code, asking some questions on the criminal code. Article 12 of the criminal code provides that the diya for murder of a man is half of that of a man. Although there have been a recommendation to amend another article, Article 42, so that the price would be equal among the genders in case of a bodily damage, there has not been a recommendation regarding Article 12 on diya. Why? The next issue I'd like to address is so-called honor killings. Article 232 of the Criminal Code provides that any male relative may kill a female relative suspected of adultery and not be prosecuted with murder. There have been recommendations to amend Article 232 so that it is equally applied to both genders. Good. However, the proposed punishment is very lenient, mere 6 months to 1 year in prison. Article 273 and 275 criminalize immoral acts, but they leave the interpretation of immoral acts to judges. According to information before us, due to the predominantly male law enforcement authorities, women are more likely to be seen as acting immorally. Are there statistical data regarding the ratio of women prosecuted and convicted of these crimes in comparison to men? The last issue I'd like to address under issue number 8 is violence against women. We take note that the report of Yemen recognizes that violence against women is a problem. However, according to information before us, reporting of domestic violence is oppressed due to the societal view that such violence should not be publicized to keep the family honor. Could the distinguished delegation indicate measures to let women have full access to justice and safety when they have been victims of such violence? Now, I'd like to jump to issue number 17 on trafficking. According to the report of Yemen, child smuggling in Yemen is largely a matter of irregular migration by children and is not child trafficking. Could the distinguished delegation provide us with further explanation as to why it is not child trafficking? And the report of Yemen states that the new section was added to the Code of Offenses and Penalties under the title Child Exploitation Offenses. Could the distinguished delegation explain to us how the amendments are implemented and enforced in practice? Finally, Madam Chairperson, I move to issue number 18, abuses of children. We regret that the report is silent once again on Article 24 altogether. And under this issue number 18, the first issue I'd like to address is sexual exploitation of children. Could the distinguished delegation provide us with information concerning sexual exploitation of girls, particularly information on temporary marriages? The next issue under number 18 is minimum age for marriage. The report of Yemen states that the House of Representatives had set marrying age at 17 years. However, in fact, an amendment to set the minimum age to 17 years was voted in favor by the House of Representatives, but was blocked by 23 parliamentarians following a report by the Sharia Legislative Committee. Could the distinguished delegation comment on the failure to amend the law? Although Article 14 of the Personal Status Law requires citizens to register marriage, there are many cases where registrations are not done, especially in rural areas. Does the government of Yemen intend to address the problem? Now, the next issue is children involved in armed conflict. We are concerned about the number of children involved in armed conflict. According to information before us, many children serve as soldiers. Is the government of Yemen taking measures to prevent children from being recruited as soldiers? And according to information before us, many schools are occupied by the military, and as a result, many children are absent from school. Could the distinguished delegation explain how the government intends to address the problems. I very much look forward to receiving replies from the distinguished delegation. Thank you very much.
Thank you, Mr. Iwasawa. I now give the floor to Mr. Neuman.
Thank you, Madam Chair. I'd like to add my warm welcome to the distinguished delegation, and I look forward to the constructive discussion that we will be having today. I apologize in advance for the length of time that I will be speaking. I have been assigned 8 of the 18 questions for this afternoon, and it is not from the joy of hearing my own voice that I will be speaking so much. I will be asking about issues 9 through 16 on the list of issues, but I won't be asking them precisely in the numerical order. Let me talk about 9, 11, 13, 14, and 15 first, and then 10, 12, and 16. Some of these are issues that are relevant to the recent crisis. Some of these are issues that reflect long-standing problems. One of the long-standing problems is addressed in issue number 9 on the subject of the death penalty and the crimes for which the death penalty is imposed. As the State Party may be aware, the current law imposes the death penalty for far too many crimes that cannot be considered, quote, the most serious crimes, unquote, within the meaning of Article 6 of the Covenant. Some examples are well known. They are not the only examples. The Covenant does not permit the death penalty to be imposed for sexual offenses, or for broadcasting false rumors, or for apostasy, which, by the way, should not be a crime at all under Article 18 of the Covenant, or for many other crimes on the list. Can I ask what steps are being taken to change as quickly as possible the reduction in the number of crimes subject to the death penalty? There are also problems that occur in practice. The Covenant does not permit the death penalty to be imposed after unfair trials, as has sometimes occurred in the State Party. And it is unclear to me whether the death penalty can be imposed in the State Party on juvenile offenders. The Covenant prohibits the death penalty for crimes that are committed before the age of 18, not merely forbidding the execution before the child reaches 18, but death penalty for crimes committed before the age of 18. Some of the texts of the State Party's laws appear to contemplate the death penalty being imposed after age of 15. Could I ask you please to clarify whether the law does formally prohibit the death penalty for crimes committed before the age of 18? There are reportedly also problems regarding the determination of the age of young defendants. Often there are no official records of birth to demonstrate a young defendant's age. Mandatory registration of births is independently a requirement under the Covenant. In the absence of birth records, what are the methods that courts use to make sure that they are not imposing the death penalty for offenses that were committed as juveniles? Regarding methods of execution, the issue of the punishment of stoning arises. It is possible that this punishment has not actually been used in recent years in the State Party. But there was a well-known case a few years ago where the sentence of stoning was imposed, and it appears to have required a great deal of international attention to prevent it from being carried out. If the State Party agrees that this punishment is no longer proper, then why not eliminate it as quickly as possible from its statutes? Issue 11 asks about the definition of torture. I believe the State Party is aware that the legal definition of criminal responsibility for torture in its legislation is too narrow and needs to be broadened to be consistent with the standards of the Covenant and the standards of the Convention Against Torture. Am I correct in that assumption? And if so, my question is simply, when will this change be made, and why not immediately? Question 13 asks about female genital mutilation and domestic violence. My colleague, Mr. IWASAWA, has already spoken about domestic violence, so I will be brief on that subject. Based on prior reports of other international mechanisms, I take it that the State Party has no effective mechanisms for preventing domestic violence, that the police are not trained to treat domestic violence as a serious problem, that shelters for women fleeing domestic violence may not exist. Is this correct, and what plans does the State Party have to deal with this issue? Regarding female genital mutilation, it appears that the state has made significant efforts to educate public opinion on the harms of such mutilation and to discourage the practice, which is widespread in certain regions. I agree that educational efforts are important and that this is not a problem that can be solved merely by enacting laws. But still, it is less clear to me what the current legal framework is. Is there a legal prohibition of female genital mutilation? Are there legal consequences of any kind in existing law for parents who inflict such mutilation on their daughters or for non-family members who participate in the mutilation? Are laws on this subject ever enforced, or is education the only method that the state is using to reduce the practice? Issue 14 concerns asylum seekers and other foreign nationals in need of protection against serious human rights violations in their countries of origin. I want to begin by recognizing that the State Party has played a very important humanitarian role in the reception and protection of refugees from Somalia. Unfortunately, the legal framework within which the state protects refugees is not very clear, and it may not have been extended as carefully to refugees who fear ill treatment if they are returned to other countries, such as Egypt, Eritrea, Ethiopia, and Syria. This raises issues under Article 7 of the Covenant and not merely issues under the Refugee Convention. May I ask what steps the State Party is taking to achieve greater consistency and regularity in its treatment of foreign nationals in need of such protection, and increasing its cooperation with the Office of the United Nations High Commissioner for Refugees with regard to non-Somali refugees? The 15th issue requested data concerning corporal punishment, including flogging and amputations. The committee needs these statistics. It may be that the State Party is not in a position to compile the exact number, but it must be able to give an estimate or a lower bound. Under the Covenant, the number should be 0 for both floggings and amputation. But it is widely reported that the numbers are not 0 and that floggings are frequent. What information does the distinguished delegation have relating to these subjects, and what is being done to eliminate these cruel punishments? The question also asks about corporal punishment of children outside the criminal justice system. The committee has been told that corporal punishment of children is not lawful in schools, but that the practice continues in schools, and that corporal punishment is not expressly forbidden in other institutional settings. Is that correct? What is being done to prohibit corporal punishment in all institutional settings, to increase compliance with this prohibition, and to educate parents on the need to use less violent methods of raising their children? Now I go back and come to questions 10, 12, and 16. This group of questions asks about investigations of allegations of extrajudicial killings, violations of international humanitarian law, enforced disappearances, torture, ill treatment by security officials and law enforcement officials, use of force against government critics by pro-government militias. It appears that these crimes, or alleged crimes, are rarely investigated and rarely prosecuted. Is that correct? But the answer also seems to be that the state party has no intention to prosecute crimes of the past. There's now a very broad amnesty law that covers crimes by government officials. I'm not sure what the extent of that term, government officials, includes, from the entire past decade and indeed for 3 decades into the past. Can the distinguished delegation clarify for us what the scope of this amnesty law is? Does it really cover such cases of extrajudicial execution, targeting of civilians, disappearances, torture, disproportionate use of force, and other serious human rights violations by government officials and military officers? If so, how is such impunity consistent with the state party's obligations under the covenant? Is it not clear that such broad impunity deprives victims of justice and encourages future violations? The enactment of the amnesty creates urgent need for stronger measures against future violations. What steps is the new government taking to ensure that in the future these violations, including extrajudicial execution and disappearances, and disproportionate use of military force will not be repeated? As has previously been discussed with regard to ongoing detentions and disappearances, there is a need for immediate remedies going forward for those who are still under detention. What steps are being taken to investigate and punish any similar violations that may have been committed after the amnesty? What is being done to signal that the amnesty is not a promise of a further amnesty in the future? And in this connection, let me ask, what is the state party's position regarding the lawfulness of targeted killings as a technique of counterterrorism? With specific reference to question 16, that question was intended to inquire into unofficial organized groups favoring the existing government who have engaged in violence against peaceful demonstrators and other political dissidents over the past year. Given that they are unofficial, are these pro-government militias outside the scope of the amnesty? And if so, what efforts are being made to investigate and prosecute the crimes that they have committed in the past year, or the crimes of others who are outside the scope of the amnesty? And in any case, what efforts will the new government make to control these militias and prevent them from committing such crimes in the future? I thank you for your patience in listening to this long list of questions. Thank you.
Thank you, Mr. Neuman. I now give the floor to Mr. O'Flaherty.
Thank you very much, Madam. And may I join with colleagues in warmly welcoming the delegation, which is headed at such a senior level, which greatly helps us in our dialogue. I have just a few additional issues which are not captured in the list of issues, but which seem to be of some importance and would need to be raised. The first has to do with the information before us to the effect that not only does the state party criminalise same-sex sexual activity, but also that it is one of the 7 countries remaining on earth that impose the death penalty for such practices. Now, this is not a case of, it's not analogous to the examples we just heard from Mr. Neuman of inappropriate use of the death penalty where a lesser sentence would be correct. This is a case, of course, where criminalisation in and of itself is a violation of the covenant. And so it would be helpful to get a statement from the delegation as to its steps to eradicate this criminal provision from its laws. Second, whilst remaining with issues of the right to life, we are of course aware, it's I think quite widely known, that many people have died in Yemen in recent years through military activity from unmanned aerial vehicles, commonly known as drones. I do not have great information as to the identity of those dozens of people who have been killed. But it would be helpful to get a sense from the delegation as to the levels of death that have taken place in recent years through the action of these unmanned vehicles, and also what actions the State Party is taking to address this issue. Is it engaged in discussion with the state from which these vehicles are being sent? Is it just generally, how is it engaging with this matter of clearly a violation of right to life that is taking place on its territory? Be very helpful for your guidance around that issue and all of the related dimensions that arise. Third, the matter of the amnesty law has been raised just now by Mr. Neuman, and let me not go back over ground that he covered. But could I ask for more information around the related programme of transitional justice that I understand the State Party is putting in place, such as a truth commission of some form? We'd be grateful to get a better understanding of the function of the institution that's being considered, and also the extent to which the design of the Commission has emerged from a process of consultation with the rights holders in the Yemen. There is clearly established today a duty, a human rights duty, to engage in a national consultative process before putting in place such initiatives as truth and reconciliation commissions. And it would be good to get a sense of how that dimension of the human rights duty has been respected by the Yemen. And finally, and again it echoes something that Mr. Neuman raised, he referred to the ambiguity regarding the extent to which juveniles might have imposed on them the death penalty. And in addition to his questions, I would be grateful for clarification from the delegation as to whether it is the case that currently proposed amendments to the Penal Code, amendments to Law 12 of 1994 on crimes and punishment, do actually envisage, the amendments do envisage the imposition of the death penalty on juvenile offenders. So there we have what apparently is a specific instance of where juveniles could indeed be sentenced to death. So in addition to the responses to the broader questions put by Mr. Neuman, it would be helpful to get a response also on that one specific matter. Thank you very much.
Thank you, Mr. Flaherty. I give the floor now to Mr. Fatala.
شكرا سيد الرئيس.
Thank you, Madam Chair. First of all, I would like to welcome the delegation of Yemen under the chairmanship of Her Excellency Minister Hooriya Ahmed. I have a number of questions, and I will not do that in a traditional manner in the same way that we used to do, because we all know that Yemen is in a transitional period, as was clarified by Her Excellency the Minister, and therefore the list of issues that we call is indeed not the way that we should deal with this discussion. And therefore, what I'm going to mention right now in terms of questions and request for clarification will actually be based on what was said by the minister, because this was based on the recent developments. As a matter of fact, when we are dealing with a country that has gone through what we call the Arab Spring, we should take into consideration that this country has gone through a number of developments. And on the other hand, we should shed the light on the intentions of a new government. And we know very well that we cannot demand of such a government or of such a state that has gone through such recent developments to give us clear-cut information with an immediate effect regarding certain achievements in the enforcement of the international covenant. At the end of her intervention, Her Excellency the Minister said very clearly that Yemen, or that she asks our committee and the other committees and bodies that were established within the treaty, that she has asked them for support and for a partnership. And in asking the ministry, or in giving my questions, I'll have to take all this into consideration. The minister said that in a term of 2 years, several measures were undertaken with the aim of enforcing the International Covenant on Civil and Political Rights. And she said that we cannot talk about such issues without taking into consideration the necessity to redress certain issues such as the stability as well as the security, because this is the main pillar for the society, and such major changes are very important. And therefore, my question is, what are the steps taken so far to implement such measures, taking into consideration the wide use of weapons in Yemen and the absence of the rule of law? The other question is that if you have indeed started such steps, and you know very well that this is the first step towards the enforcement of the covenant. Linking this to another question or comment, I welcome the fact that a Ministry for Human Rights was established in Yemen. Who will be responsible for the implementation of Yemen's commitments under the covenant? And the other question is, to what extent there is cooperation with the security apparatus? Because we all know that the security personnel in many countries, in some cases or in many cases, do not respect the human rights principles. And we all know that there is a very important link between the security apparatus on the one hand and the respect of human rights on the other side. The minister has also referred to the establishment of the Truth and Conciliation Commission that will embark on a number of remedies for the victims. Also, the minister spoke about an independent judiciary. What will be the guarantees if you are going to establish such an independent body? What are the guarantees of such independence?
I give the floor to Ms. Motov now.
Madame la Présidente.
Madam Chair, I would like to thank the delegation of Yemen for the presentation they've made to us today. I must admit that I agree with Mr. Fathallah and in what he just said. I think that the issues and the questions that we asked to the delegation were posed before the changes that took place in Yemen. I have always, in fact, said that we must have human rights standards for countries that are part of the covenant. But what is the country like? Because we could ask for a great deal of things, but at the outset and in the framework of Yemen, we need to ask how a country that has gone from such a state of human rights before the events and the elections, how can this country now be aligned with the covenant? So this is my question. So this could fall under Article 4. Now, as far as I'm concerned, and perhaps this is a dilemma that many countries are dealing with now, exactly how can we see when we have impunity of people who have massively violated human rights, how can we really make up for the past, and how can we link this to the past and make up for it? Because I believe that the experiences of all countries that have not truly taken stock of what has happened, and there are certain measures that have been taken now in Yemen with regard to the impunity of Mr. Sal and everyone who has led the country over that period, where we have had very massive human rights violations. How are all of these people now going to make a contribution to the positive steps that are going to be needed to go forward? This is my question. Why did the government decide that these will be positive measures that will be taken so that in the future we can really implement the covenant? Perhaps we could have ensured that to ensure that there is no impunity, that before installing the mechanism, any kind of mechanism of justice or of truth finding, we would need to make a distinction for people who may have committed human rights violations or those who have not committed violations against human rights. We are talking about executions, women's rights, torture, with regard to all of these possible violations. And when we look at Yemen and what happened 2-3 years ago and the state of Yemen today, we cannot have a situation we have had human rights violations 2-3 years ago. Now we don't. We need to ask ourselves, how can we ensure that we have minimum progress so that we can go forward and so that we really turn the page? My second question, and here I also agree with Mr. Fatala, I think that it is crucial that for any state, before having democracy and human rights, we need to have a rule of law. If we do not have a rule of law, if we do not have a justice system and a police that works efficiently, we cannot do anything with regard to human rights and the list of issues that we have before us. So I believe that this is also a priority. In other words, how can we truly create a rule of law, a state of law, and also maintaining human rights? These are essential issues, I believe, with regard to the answers provided by the delegation. How do we kick off a democratic tradition in a country that has really suffered and has seen such grave violations of human rights that my colleagues have mentioned, and that now we can put behind us? We cannot do it overnight. That's not possible. That has never happened in any country, and I don't think it will. It's going to necessitate a great deal of time. But we need to look at things positively. We need to know what are the stages that the country needs to go through and what are the priorities. Thank you.
And the last person on the list is Mr. Caleb. You have the floor, sir.
Thank you, Madam Chairperson. I would like to join my colleagues in warmly welcoming the distinguished delegation. I will be short because I just have one question. A question that is related to issue number 14 on refugees and asylum seekers. Yemen, besides receiving a considerable number of refugees, is also confronted with a serious problem regarding internal displacement. In a previous capacity, I
had the opportunity to visit your country in 2010 and look at the internal displacement situation. I was impressed by the willingness to help these people, but it was also clear that there was a lack of guidance, a lack of institutional capacity. And I managed to assist the government at that time in drafting a strategy on internal displacement. The previous government never adopted this strategy, which I felt was quite relevant and good and would have been helpful. And the question is whether the present government would be ready to first adapt the draft strategy to the present circumstances and then adopt it. I think it would be an important step forward, both in getting support from the outside to deal with the problem, but also in strengthening the capacities of the government to deal with a very, very vulnerable group of people who have very often become victims of serious human rights violations. Thank you very much.
Thank you, Mr. Kaling. The members of the committee have finished with their questions and comments. Your Excellency, I will give your delegation 15 minutes within which to prepare your responses, and that means we shall resume the meeting at 5 o'clock, and hopefully you'll have at least an hour or so to respond to the many points that have been raised. Is that all right?
Thank you.
The meeting is suspended. To Her Excellency, Minister Hooriya Ahmed, to begin responding to the issues raised by the members of the committee. You have the floor, Madam.
Yes, thank you very much, Chairperson. Thank you.
At the outset, I would like to thank all members of the committee for their productive participation, their good questions concerning the replies of the Republic of Yemen and concerning the report as well. This was useful for us and will assist us in developing and improving our work concerning human rights and the promotion of human rights. I will address some of the questions, and my colleagues will continue with further replies. First of all, concerning the National Accord government and its commitment to human rights, and being based on the Constitution. In fact, now the terms of reference of the National Accord government, upon which they have prepared their program for the next 2 years, the transitional period, undoubtedly the Constitution of Yemen in general applies, but there are also terms of reference that are now above the Constitution. And this is the initiative of the Gulf Cooperation Council, the mechanism of implementation of the initiative, and the Security Council Resolution 2014, and the recommendations of the Human Rights Council to the government of Yemen. These are now principal terms of reference for the government. When we formulated the program of the government, we relied on these terms of reference and the importance of implementing them. Undoubtedly, the Constitution is still in effect, but there are articles in it that have been suspended. For example, the early presidential elections were not part of the Constitution. They were based on the political accord on the initiative and on its mechanism of implementation. Concerning the South and the rights of the population of the South, there was already a suggestion of administrative decentralization. There was also a question of local rule that was being discussed, but apparently the recent events are going to supersede the whole question of administrative decentralization or local rule with wide authority, because this is going to be addressed in the National Reconciliation Conference, and there are already steps being taken. There was a meeting attended by representatives of the South, and there are steps which we hope will lead to the people of the South, suggesting their view, their opinions concerning the issue of the South. In fact, the President, Mr. Abdurrabbo Mansour, said that there were no red lines in this discussion. And this is going to be dealt with seriously, and there will be a just solution for the question of the South, because the international community and the local community and the people itself all want to preserve the unity and stability of Yemen and its stability. This is a goal that is encouraged by the regional partners and by the entire international community. But the question of a national dialogue and the participation of Southern forces in this dialogue, this is what will determine the features of the new state. We are going to create a new constitution. I don't want to anticipate any of that, because this is what is going to be proposed and dealt with by the political forces currently active on the scene. The Southerners, there are no Southerners in detention now. You mentioned Qasim Askar and Fadi Benoum. These have been released. Fadi Baum also, who had been in prison, was the subject of attention by the government, and upon his request, he was sent to the Kingdom of Saudi Arabia for medical treatment, and he is now free to move about. There are currently no Southerners under detention. Concerning the early retirement of Southerners in the army, this did happen after the events of 1994, but the draft transitional law, which is still a transitional justice law, which is still a draft law, does address the question of compensation for the early retirees. Many of the outstanding issues, many of the problems that were being discussed are being addressed by the draft transitional justice law. However, retirement was done according to the law, and it is important in order to pump new blood into a local administration and provide employment for the youth, because there's a large number of young people who are unemployed. So the retirement also had other economic reasons and not merely political calculations. Concerning Article 6 of the Constitution and the respect for international covenants and agreements, and Yemen's respect for them and the need to reflect them and embody them in national laws, the Constitution says so, and Yemen has signed over 60 international covenants and treaties. And we in the Ministry of Human Rights, also in the National Accord government, have a policy of maintaining the policy to align international agreements with national laws. National laws must correspond completely to international agreements to which Yemen is a party and which therefore need to be enforced. This is something which the National Accord government will in fact try to adopt this approach with great attention, because ultimately this realizes human rights and will enforce and make effective international laws and standards in the realm of human rights. There was a question whether the government has the capacity to maintain the security in the country. In fact, Yemen does face many difficulties, and there are areas that remain outside the control of the state. We have armed groups, we have terrorist groups. Al-Qaeda is present and active in some areas. We have the Houthis who control certain areas. So undoubtedly, the National Accord government still faces some difficulties and problems where it cannot extend its authority throughout the country. But through these 2 years and through our own efforts and with the support of the international community, because the international and the regional community are bound are committed to support the government of Yemen to achieve stability and security, because if we cannot achieve stability and security in Yemen, and if Yemen were to be overcome by chaos, this is not going to affect us. It will affect regional and international peace and security. Yemen overlooks some very important waterways, and therefore the spread of chaos or violence will not affect Yemen alone, but will affect international maritime activities, will affect its neighbors, who also have very important strategic interests in common with Yemen and with other countries. Therefore, the government of Yemen must extend its authority throughout the country. Concerning the independent entity for human rights, we have started with some efforts, but they were simple efforts. The European Union submitted or carried out consultation efforts for the previous ministry in order to help create this entity. The entity now is covered by the transitional justice law, but the Ministry of Human Rights looks at this entity as an independent subject which cannot be put within the transitional justice law. So we have therefore submitted an initial concept of the legal foundations for the creation of this entity, its terms of reference, how it can be structured, and the technical teams in the Ministry of Human Rights, in consultation with other government entities and NGOs or civil society organizations, we are drafting the basic law of this entity, though it is covered by the transitional justice law, but we found it better to separate it as a distinct subject, which we deal with great seriousness and attention as an independent and separate matter. We think that perhaps within 1 year, this entity will be in existence. It will be an independent entity to promote human rights. True, we do have the ministry, but the ministry in the end is a government entity. An independent entity will play a greater role in promoting human rights. Concerning the lack of respect by security forces for personal freedoms and illegal detentions, the last year has witnessed many transgressions and violations because of the events. And I have mentioned that in my statement. I said that many security and military establishments do suffer from inadequate capacities. In many cases, they are not aware of the law. They do not understand the legal foundations for dealing with people. And sometimes there is a violation of the law or transgression against it. These are issues that must be addressed through training and through the reform of security and military institutions. This is part of the reform package covered by the transitional justice law and project, because the military and security institutions which were involved in human rights violations must be retrained, must be reformed. It was also mentioned in the transitional justice law that military commanders or officers who were suspect of human rights violations should be purged, or that the police forces and security forces should be purged of these individuals. This draft law now is being widely discussed with civil society organizations, with legal organizations, with lawyers and judges, and with those who are affected by this law, because this is going to affect their livelihood. And their points of view will be taken into consideration when drafting the final version of this law, which will be submitted to the Council of Ministers, which will study it before submitting it to the Parliament. The Parliament itself represents the entire people and will take into consideration any amendments submitted by the various parties concerning this draft law before finally adopting it and making it in force. concerning punishment of officials responsible for violations of human rights. In fact, our ministry has sent letters and has carried out visits to security establishments, and we discussed these matters with them. They said that some members of the security and police forces and military establishments have been detained because of their use of excessive force. These violations are under investigation by the military justice system. Concerning the question of women, there is, first of all, a government entity responsible for women, for developing policies to improve the status of women. The National Commission for Women had suggested a series of legal amendments to improve the status of women. A large part of these legal amendments have, in fact, been approved in the parliament and are now in force. For example, the law of nationality. Yemeni women and their children, women who are married to non-citizens and their children, can now enjoy the same privileges enjoyed by a man who is married to a non-citizen. There were amendments to the labor law, the social security law. Some of these amendments have been approved in the personal status law. Some amendments have been accepted, but some were not. And I can't say actually they were not accepted. I would say they are still being discussed with the relevant committees in the House of Representatives. The one amendment that we faced a great difficulty in approving it is defining a minimum age for marriage in the law. We faced a lot of difficulty with adopting that law in the personal status law. As a member of this distinguished committee did mention, in 2009 there was an initial approval of the draft law, but then it was suspended. It was suspended, and the relevant committee, the Committee for Codification of Sharia law, requested further time to discuss it. We, as women's organizations and women's leaderships, felt that this suspension had gone on for a very, very long time. There were also other problems in the House of Representatives itself, which was suspended, especially after the event which took place in the presidential palace in June. So the parliament was suspended. And this was not among its priorities. There were other matters of much greater priority in the country, and compared to these issues related to women, we consider these matters as priority issues because they affect women and female children. But decision makers had a different view because the country was confronting many, many other problems. And so it was not submitted for discussion at that time. But we, as parties interested in human rights, still consider this as among our priorities, the rights of female children. Concerning political representation, we have also discussed the implementation of a quota system, especially in the law of public elections, referendum, and the law of political parties. But we encountered resistance from political parties. Now, within the new constitution, we would like to make that a provision in the constitution, because this legal change and institutional change is important in order to overcome the cultural resistance against women, especially women in positions of decision-making. If we manage to adopt such a constitutional provision of a quota system, we would be successful. The Committee for Government Reform had established 30% as a target, And now the target is 20%, not only in the parliament, but throughout government institutions, which are filled by appointment, such as the Consultative Council and local councils and various government entities. We want to raise the ratio of women to 20%, while 30% would remain as a strategic demand and an objective to be achieved over the long term. But if the more this is part of the law and the constitution, the easier it would be to achieve that. But beyond that, the agreements between the parties were informal agreements or words of honor, and sometimes they were not respected. But if this were to become part of the law, then it would be binding on everyone. Of course, in the elections, women participated greatly. 43% of the electorate were women. Also, women were encouraged to register in the electoral rolls, and this would increase the participation of women. But what we also want to increase the number of female candidates and the number of women who do win seats in the House of Representatives. We might have to resort to we might implement the system of a relative list, which would be more fair to women and would encourage parties to place more women candidates on their list, so that if the list were to win, this would lead to a greater number of women as members of parliament. These are some of the ideas that are being discussed now to be submitted to the National Accord Conference. There is truly a shortage in the number of women judges and general prosecutors, but this number is increasing gradually. Women do go to study in law schools and in Sharia schools, and then they do get qualified in the High Institute for Judges. Until 2004, the High Institute for Judges did not accept women. But after that, we have pushed for the admission of women into the High Institute for the Training of Judges, so that women can be trained to work as judges. And now their numbers are increasing, but it's not enough. In the police forces also, since women were first admitted into the police forces, the numbers have been increasing. But as in the judicial system, the numbers are not satisfactory yet. The problem is not in the law. The problem has to do with the wishes of the girls and their families, and in encouraging them to pursue training to work in the police forces. Concerning the education of women and the status of women in education, unfortunately, illiteracy is still widespread among women, especially in rural areas. In Yemen, 60%, indeed 70% of Yemen is categorized as rural areas. In rural areas, girls go to primary education, and then they are withdrawn from school at an early age, where they often revert to illiteracy, also because early marriage is widespread. Traditions are very influential here, and girls and women are more involved in domestic work as well as working in the field. These are among the difficulties that confront the education of women. 4 years ago, the government of Yemen has sought to revoke or cancel schooling fees for girls, which were symbolic to start with. There are also efforts by NGOs and by international organizations to encourage the schooling of girls, such as the World Food Program, which provides subsidies to or food assistance to families to encourage them to keep their girls in school. And this has helped keep girls in school and encourage them to go at least finish primary education, if not more. We also encourage girls to pursue secondary education and post-secondary education. This doesn't happen very much in rural areas, unfortunately. And so, therefore, 60% of Yemeni women are still illiterate. Concerning the number of women who remain detained unwillingly after the end of their sentences, there are women who remain in prison, especially when the crime has to do with honor and the family does not wish to receive the woman after the end of their sentence, so the woman stays in prison or are received by a women's organization. Some women's organizations who have created shelters for women as a step for reintegrating them into society. They remain at the shelter for a long time until the family is convinced to reaccept their daughter. But unfortunately, in honor problems, the families do not wish to receive their daughters again. Including marginalized groups such as Al-Akhdam community, there is no discrimination against this community, but they do have their own self-isolation. The schools are open to their children, and many of them go to school and finish school, and many of them have created civil society organizations to defend their rights. The law does not include any provision to exclude or marginalize such communities. But these are practices that need to be fought by raising awareness among the members of this community and outside in the wider community, but there is no legal impediment. Concerning polygamy, we do not have statistical studies about the spread of this problem, but in any case, this and many other issues are governed by the laws of Islamic Sharia. The principal source for legislation, according to the Constitution, is Islamic Sharia, Islamic law. But I would here want to reaffirm that Islamic Sharia requires justice and fairness and equity in treatment and expenditure. And if a wife feels she is being treated unfairly, she can demand separation and an end to marriage, a divorce. That is within her rights. About women not being allowed to leave the house without her husband's right, it's not as clear-cut as that, or as conclusive as and firm as that. Women and wives are free, do come and go as they please. It's not as bad as this. We move about freely. We do not have such limitations on our movement. Concerning marital rape, we do not have reports. There are no women who come forward and complain about this. We have no studies or statistics on this. It might happen on rare occasions. During the 10 years that I have worked in the National Commission for Women and in various organizations that focus on women, we have not received any complaints or letters on this. Perhaps because this is a sensitive subject and women do not resort to filing a complaint against a husband on the grounds of marital rape. So we don't have information and we do not have reports. Perhaps we do need studies if this were to become a problem or a phenomenon. But until now, this is not a problem in Yemeni society. As to forcing women to accept marriage, the law states, and Islamic Sharia stipulates, that the woman must be asked whether she had been previously married or not, or a virgin unmarried previously. She must give her approval. But there are practices where the father might be oppressive and might force a marriage upon his daughter. This does happen, and the girl is forced to accept. But from the point of view of the law and the Sharia, there is no forced marriages, and such a marriage from the point of view of Islamic Sharia would be considered invalid. Concerning inheritance, there are cases where, in fact, women inherit a larger portion than men. Because in Islamic Sharia, there are certain situations that are covered. It's not one single rule that applies. But in the case of girls inheriting from their father, according to Islamic Sharia, women are not obliged to provide for their families, to cover their expenditure of the family. She can take her fortune and withhold it to herself. However, the father or the male is obligated legally to provide for the family. But this is a matter of practices and social custom. Some areas do, in fact, prevent women from inheriting. In the government, we have a program for raising awareness about the rights of women to inherit according to the law. And as I have explained, there are cases where women inherit a greater portion than men. For example, if it's the child who passes away and the mother who inherits, in this case, the mother would have the greater share of the inheritance. Concerning the blood money, in the case of the death of a woman, we do demand a legal provision to cover that. Right now, the legal provision in the criminal law states that the blood money in the case of the death of a woman is half that of in the case of the death of a man. We demand that the amount be equalized. This, in fact, is not based on Islamic religious law. There is no text concerning that, but there are various schools of thought in Islamic jurisprudence that have different interpretations, and Yemeni legislation, which is open to all interpretations, we encourage it to adopt the more positive interpretation of Islamic Sharia in this respect. Women are active in NGOs, and this is part of the third and fourth 5-year plan of the government, which include an entire chapter concerning violence against women and demanding government reforms according to CEDAW and implementing CEDAW, the Convention on the Elimination of all forms of discrimination against women. There are also international organizations such as Oxfam, which are very active. The UNFPA, UN Women now, are all involved and interested. We have preliminary studies about the extent of this problem of violence against women, but earlier on there used to be a responsiveness from some parties when we discussed that, pardon me. Some parties were sensitive to this issue when we discussed it. Now, this sensitivity has disappeared largely, and we find greater responsiveness when we discuss this by government entities and a willingness to discuss creating shelters if there is violence against women and the wife or the daughter cannot return home. Then there are services that can be offered to women. Concerning illegal immigration, we do have some preliminary studies concerning the illegal immigration of children, especially to neighboring countries. Unfortunately, some children, with the approval or the consent of their families, go to neighboring countries. In fact, the families get paid for that. In order to earn money, in order to assist their families and provide for them. This is unfortunately all connected to poverty. We do not have in-depth studies, analytical studies so far about this. There are reports that this problem is receding also because of the concern of neighboring countries about the infiltration of some illegal groups or terrorist groups. But so we don't have studies, but there are indications that it might be receding. During the crisis last year, we did not witness a large wave of immigration by children or juveniles to neighboring countries.
حول موضوع الاستغلال الجنسي للبنات والزواج المؤقت. حول موضوع الاستغلال الجنسي للبنات والزواج المؤقت. الزواج المؤقت أو ما يسمى كان بالزواج السياحي هذا تراجع إلى حد كبير جدا. لا نرى ذلك التدفق من السواح من المناطق. Yes.
Can you just correct the translation?
Yeah,
it's
okay.
A bit of a problem. We're having a technical problem.
Hello?
Please go ahead. Regarding the temporary marriage, this for 5 or 6 years ago, this was a very major phenomenon. However, we have introduced a number of regulations and control in terms of those men who would come to Yemen to look for a young wife. And this is also connected to poverty. And one of the most important regulations was the acceptance that was issued by the Ministry of Foreign Affairs of the country from which that man came, because there were certain circumstances where a man would come to Yemen and would get married to a young woman, and then they would have children, and then after certain years the children would come back to Yemen and a lot of problems would start. However, for the past years we have curtailed this phenomenon, and therefore I would say that we haven't received any information referring to the fact that there were new marriages of that kind. Regarding the children and school buildings that were occupied as warehouses for weapons, we have referred to the competent authorities, and we have requested them to send reports on this topic, and we have received information to the effect that there are no such thing as school buildings used as warehouses for weapons. However, some school buildings were occupied by displaced people who had to escape from the hotspots of disputes. And indeed, this so happened because there were some places like Sana'a, Taiz, and Aden, where there were the armed parties that were everywhere in those cities. As I said, there are only some displaced people who occupied those buildings. Regarding the capital punishment for a number, including apostasy, there were no such cases, because according to the Constitution we have the freedom of conviction, because we understand that a person may have the right to change his religious convictions. Regarding the physical punishment, I believe that the government does not have such provisions. However, in the province of Abiyan, there are certain practices that are practiced by certain armed groups, and also, and especially the outlaws that have been doing this in against the minor in particular. We have spoken to the military entities that said that they have recruited minor children to be used in armed confrontations. it did happen, and we know that one of those military parties or militias, they had indeed minor children, and this was because of poverty. The UNICEF and a number of organizations have brought back those children to their families and to the educational institutions. I personally have asked a number of the leaders in certain security and military entities, and they replied saying that they have a committee whose responsibility was to investigate as to the age of those persons engaged in military actions. And there are also entities that are responsible for the juvenile, and they can assess the age of the person under question. The circumcision and the female genital mutilation, there was a plan to reduce this by the rate of 30%. I have to admit that this phenomenon is in some of the provinces, especially those closer to the African Horn countries, and we have it in Egypt and in some of the African countries, and we have had our dialogue with some of the religious institutions, and you have to understand that the religious recourse has a great impact in our country, and therefore we had our dialogue with the representatives of the religious institutions and some people who are in fact more enlightened than others, and they do confirm that such a phenomenon does not have any roots stemming from religion itself. In 1999, there was a ban on such practices, and also we have had a campaign launched to increase the awareness as to such harmful practices. There was no provision regarding the female genital mutilation in our law, and up till now there are no sanctions as to those who perform such mutilation. Regarding the immunity or the amnesty law, this, I would say, was maybe one of the best options we had. It was maybe the most difficult one, but we had to take into consideration the complexity of the reality, and we opted for the immunity versus the transitional justice. So the solution was to give immunity at the same time that we had to go for a more for a frank dialogue between the parties concerned, and with the aim that this should be kept in the national memory of our country, of our nation, so that we would look for a number of solutions and also a number of remedies and compensations for the victims and the rehabilitation of people, and also the financial compensations that would be paid as part and parcel of a holistic program for the future. There is a project law regarding immunity. Well, since 1990, Yemen has become a new country with the unity of both North and South Yemen. And up till now, there is a draft law that has not determined the duration of the interim measures undertaken so far. As for terrorism and the extrajudiciary killings, of course, Yemen is committed to the international agreements, and Yemen itself was harmed by terrorism, especially taking into consideration what happened to tourists who were victims of terrorism, and this harmed us a lot. And this issue is connected with what is happening on the international scale. We know that civilians were victims of terrorism. We know that women and children were victims of terrorism. However, we do not have enough information on this topic. This issue was tackled on supreme level with the United States of America. There were certain conversations going on with the USA regarding the unmanned vehicles, regarding the measures undertaken regarding the combating of terrorism. We know that there were certain maneuvers in the Arab Sea and the Gulf. However, there was no enough transparency regarding this matter, and actually we were astonished how come Yemeni civilians that had nothing to do with terrorism, like what happened in Ma'jala, this issue was not understood at all for us. We didn't understand how did this happen, and as a matter of fact, all the aspects of all this issue are really bothering us, especially that the victims are civilians. The armed militias who have illegal activities, of course, the weapons and arms should be withdrawn. And this was something that was studied by the parliament. There was a draft law that was proposed with the aim of withdrawing the weapons, because they should not have the weapons, because this was a danger vis-à-vis the society. Only the army should be the entity that had weapons. But within the circumstances of general chaos, there were indeed militias that illegally had possession of weapons. As a matter of fact, this is one of the tasks and responsibilities of the military entities. People should not have weapons and shouldn't be moving from one place to another in towns and cities with weapons and arms. And this matter should be eradicated. For the capital punishment, for the homosexuals, I believe that this matter I believe that maybe there were rare cases. It is true that our law is based on the Islamic Sharia. However, it did not happen that we had capital punishment sentences against homosexuals. This never happened. Regarding the Truth and Conciliation Commission, this is not a judiciary or a judicial entity. It does not have any judicial authority. However, It is an entity that aims at encouraging people to think forward about the future and not about the past. When we speak about the past, it is with the aim to eradicate such practices and not to have such practices duplicated in the future. Regarding the refugees, Yemen, although we had difficulties and in spite of poverty, in 2011, when we expected that there will be a reduction in the displaced and in the numbers of the refugees, we have received a lot of refugees from the African Horn countries, and there is a representative of the Higher Commissioner, the UNHCR, and Yemen has signed a number of agreements, and especially regarding the refugees and the asylum. And on the other hand, there are many people who were integrated in the society, although there are still people who live in camps. International organizations that are concerned with the issues of the refugees continue to provide support to the refugees and those who have sought asylum. There's a number of issues, but my colleague is going to cover them.
أشكر الأخت الوزيرة.
We've got 5 minutes. Unfortunately, we have to end the meeting at 6. Thank you.
أنا فعلا
In the name of God, the merciful, the compassionate, thank you. I am aware that I only have 5 minutes. Her Excellency, the Minister, has covered a wide range of topics, and she is my superior at work. So, in any case, I was not going to interrupt her while she made her statement. So, I believe that the 5 minutes will not be sufficient. So hopefully our replies will also come tomorrow, and we will have the response ready then. So thank you very much, Madam.
Well, that being the case, I have no option but to adjourn the meeting. And we hope to continue then tomorrow with replies from the delegation. Thank you very much. Thank you very much. The meeting is adjourned.